Hello and welcome everyone to today's webinar. My name is Melissa Abache and I will be hosting today's webinar. As you can see, we're very happy to be hosting you today for our Koch University LLM program in private law. This is one of a series of webinars to be, that we want to showcase all the different aspects of our LLM programs. So as we wait for all participants to join today's webinar, I would like to first give a brief introduction for our panelists today. We are going to have as the main activity of today's webinar is a sample lecture from one of our private law courses. And that lecture is going to be delivered by Assistant Professor Ishik Onai, who is a member of our School of Law at Koch University. His research areas, of course, he will introduce himself in more detail once the time starts. His research areas are in contract law, law of torts, law of inheritance, law of property, family law, and European private law. And of course, you can see on our website more details about his research and other work. We're also joined today by Assistant Professor Aisha Gulbura, who is the Associate Dean for our School of Law at Koch University. She will be here to provide us a brief introduction to our LLM programs in general and information about the different curriculum options and tracks that are available to students. And we'll also have Ms. Esra Ozcan, who is the Executive Director of our School of Law at Koch University, and she will provide us with an overview of the admission-related aspects of the program. So the lecture part, I just want to go over some housekeeping information to make sure we're all on the same page for today. The sample lecture is scheduled to have a duration of about 30 minutes, so we should have enough time to do questions and answers at the end of the whole webinar. So this webinar is being recorded and you will receive the webinar video one day later. You're going to receive an automatic email from Zoom with a link to our YouTube channel where you can see the webinar video. Once we come to the Q&A part of the webinar, we kindly ask you to type your questions on the Q&A section of the screen, not on the chat. We're going to use the chat if we need to broadcast some messages to all attendees. If possible, please type one question at a time so that we can go over them and so that all attendees can see the questions one by one. And of course, we will aim to answer not only lecture and topic related questions, and we will give priority to those. And then if time allows, we will also go over admission related questions. Of course, all the admission information is available on the program website, which we will be showing at the end of the webinar. So with that, it's a very brief introduction. I would kindly ask Professor Ishik to open his camera and his microphone so that we can start the lecture part of today's webinar and for him to introduce himself. We're very grateful for you for being here and joining us today. He's going to share his screen to get the lecture started.
Thank you very much, both for the introduction and for the information you have given. Today, I will give you a sample lecture on comparative contract law. Before I start, I should tell you that this is one of the courses that I teach in the LLM program, and as you will see, it is a mandatory course. And during this course, what I do is I do select several problems of contract law and analyze these problems from a comparative perspective. When I say comparative perspective, I mean we look at solutions by different legal systems. And on top of that, we also have a look at some international instruments, such as the Unidora rules, principles of European contract law, DCFR, draft common frame of reference, and the CISG. And one of the good things about having international students in the program is they enrich the content of the course as well, because what I do in the courses is that I ask them to refresh their memories about their own legal system concerning the topic we will discuss in the lecture. And then we have an interactive class where everyone can share solutions from their own jurisdictions as well. So having international students in the course is really an asset in that sense. You may wonder how we look at different jurisdictions because you may not speak the language of that jurisdiction, but luckily these days we have very good sources in English which deal with contract law in a comparative context. I mainly use these 3 books that you see on the slide. The first book is actually, I use it very often because it gives you some case studies and provides you with materials from different jurisdictions in English. That gives you the chance to have a look at these materials and then answer the questions that are being asked pertaining to that case. And the latter 2 books are textbooks, and they give information on contract law in a comparative context as well, and they are very helpful. On top of that, you get some readings and experts from other books, articles, etc. So what I will do today, I will just give a very short version of the first class I do in the Law 504 course. I will first talk about comparative law in general. So the objectives of comparative law, why do we compare and how do we compare? Then I will specifically talk about contract law as the object of comparative law. For that, I will discuss why we need contract law, and I will tell you about a little bit about the historical background of contract law, and give you an overview of the legal traditions. And lastly, I will talk about harmonization efforts pertaining to contract law in Europe and in the international context. So let us start with our first question. So why do we compare at all? One answer to this question could be simple curiosity, because as a lawyer trained in a specific jurisdictions, you may wonder about the other jurisdictions, how they solve their problems, etc. So actually the main motivating drive to engage in comparative law studies is usually curiosity. But it's not limited to that. It's also helpful for overcoming the bias towards the superiority of one's own national law, because as lawyers, we are trained usually within the boundaries of a national law system, and we always tend to think that the solutions adopted there are the best ones. Engaging in comparative law studies gives you a perspective. You'd sometimes notice that what you have learned in your undergraduate courses may not have been the ideal solutions to given problems, and seeing other jurisdictions really helps that. Thirdly, engaging in comparative law studies is also helpful, useful for legal transplants. When I mean legal transplants, when I say legal transplants, I mean some countries sometimes do have to make drastic changes in their legislation. For example, that was the case for Turkey in the 20s. It was more recently also the case for post-Soviet countries after the fall of the Soviet Republic. So when you quickly have to change your legal system, the easiest way to do that is to adopt an already existing system. And to do that, you have to engage in comparative studies as well. Next, comparative law helps for the practice of law as well. And now I will give you examples regarding to that. For example, there was in Germany a case, what we call wrongful life cases. In that case, the dispute was such, there was a disabled child who was born due to the negligence of the doctor, because the doctor could spot a genetic disability of the child, but failed to do so and did not warn the parents. So the child was born, and what happened was the child itself sued the doctor for damages. So the question here was a very unusual one, because when you usually calculate damages, you look at the state that you are in now after the breach of contract or after the tort, and you look at the hypothetical state where you would have been had the breach or tort not occurred. So what's the hypothetical scenario here? The child would not have been born at all. The child would not have existed. So that was a very interesting problem, and it was the first time that German courts had to deal with such an issue. And while doing that, they made use of comparative law. Here you see a German quote from the decision by the German Supreme Court. And what they say here basically is they refer to English law and explain their solutions. They also refer to the United States law and explain their decisions. So you see the courts themselves resort to comparative law when they are faced with cases that they have not had to deal before. Another example comes from Canada. This is the CNR case. What happened here was that a boat owned by D hits a bridge and damages it. That's a typical tort case. But the problem here was that the bridge was owned by A. Okay, the A suffered damages, that's okay. But CNR was operating a railway on that bridge. So actually, CNR's bridge was not damaged. So could CNR sue for damages? That was the question. And for those of you who have studied in civil law may know of a concept called pure economic loss. So the question was, under Canadian law, can pure economic loss be compensated in that case? And what the Canadian court did in that case is they looked at civil law solutions to the problem. For example, here in this case, they looked at Quebec, which is a mixed system. I will tell you about that later, and France, which is a civil law country, and explained their solutions, and German law as well. So while dealing with this issue, they made extensive use of comparative law. Also, Switzerland was mentioned as a quote, and in the end, they decided that there should be liability. The result was 5-4, if you are curious about the outcome. Another examples come from the UK. These are more recent trends that I will mention. For example, in 2015, there was a case on medical negligence. And this case here, it's decided by the Supreme Court, extensively mentions Canadian and Australian cases in its evaluations. Then there was another question that had to be answered. Some of you may know the common law countries distinguish between contractual penalties and liquidated damages, and liquidated damages are enforceable, whereas contractual penalties are not. But in this case, in 2015, the Supreme Court also cited French and German law, saying that in civil law countries, contractual penalties are enforceable as well. So they made use of those jurisdictions. Another recent development in the UK is that the law of unjust enrichment has been developing very rapidly. And in these developments, the model of civil law solutions are taken into account. We see an example of that in a case in 2017. For those of you who are trained in Turkey as lawyers, I could give you a familiar example from our Court of Cassation. In 1992, the court had to decide a case where they made use of a German doctrine, the so-called contract with protective effect for third parties. What happened in that case was someone bought an LPG, and the LPG was defective and exploded. And it not only caused damage to the buyer himself, it also caused damage to the neighbor of the buyer who came to help. So the question here was, could the neighbor claim damages as well based on contract? And the court said yes, citing German sources extensively. The court said, well, there is a theory under German law, which we could also use under Turkish law, the contract with protective effect for third parties. So you may wonder, how does that happen? How do courts go and make use of foreign rules and solutions? Methodologically, how does it work? The answer to that in the context of Turkish law is easy. Because in the Turkish Civil Code, when the code talks about the application of law, it gives the judge the option to follow doctrine and case law. And this doctrine and case law does not necessarily have to be Turkish doctrine or Turkish case law. This article, paragraph 3 of Article 1 of the Civil Code, gives the judge the authority to make use of foreign law as well, especially Swiss doctrine and Swiss case law are very relevant in that case, because as you know, we have taken our civil code from Switzerland. So we have answered the question, why do we compare to a certain extent? There is another reason why we compare, which is harmonization, but I will come to that in the third part of my presentation. So let's talk about the way we compare. How do we compare? First, there's a basic distinction that has to be made between micro and macro comparison. So when you talk about micro comparison, you are talking about a specific problem. You're focusing on a particular legal problem. For example, you are asking the question, how, when does risk pass in sales contracts? That answering that question would be an example of engaging in a micro comparison. But what you could also do is to ask broader question about the legal system itself. For example, you could ask the question, what rules do judges play in proceedings? Or what kind of authority do precedents have? Such questions are considered as macro comparison questions. To have a good understanding and to reach healthy solutions, you would have to engage in both macro and micro comparison. For example, you may have heard that, for example, in the US, there are sometimes astronomical figures as damages we hear are awarded by courts. This may surprise you. There is the famous example of a woman who spilled hot coffee from McDonald's and got millions of dollars of compensation. That sounds very weird to a civil law, to a person coming from civil law. But if you look at it from a broader perspective, for example, you may notice that US attorneys usually take 30 to 50% of the compensation as attorney fees. So when you consider that, the amount that is left to the damaged person is not that surprising to a civil lawyer as well. So to reach, to understand a different legal system, you have to look at the system in general as well. And when you are doing a micro comparison, it is argued that you should adopt a functional approach. This is explained in a famous book by Zweigert and Kötz about comparative law. So what they mean is you should not be limited to the distinctions and categories each legal system makes. For example, a solution to a problem may be found in contract law in one jurisdiction, whereas it may be found in tort law in another jurisdiction. An example of that comes from the UK, a House of Lords decision, where it was discussed whether an attorney would be liable if they have drafted an invalid will, and because of that, the beneficiaries did not get anything from the deceased person. Would then the beneficiaries be entitled to damages based on contract? They had to discuss that, and when you look at the solution, you see that certain civil law jurisdictions in that example would use the protective effect of the contractual relationship towards third parties that we just seen under the LPG case, whereas the solution adopted under the UK law was based on tort law. Another important thing that you have to notice is the difference between the law in the books and law in action. What do we mean by that? Well, simply looking at the black letter rules may not give you a real idea about the jurisdiction you are analyzing. You have to also look how these rules are applied in action. You have to look at case law. You have to look at other studies that explain how these rules are applied, etc. So simply comparing different codes does not really make a good exercise of comparative law. So I will now come to the second part of my presentation, where I will talk about contract law as the object of comparative law. You may have noticed that I have given already examples from contract law and tort law in the first part, but now let's talk about contract law and why it is a good field to engage in comparative studies. It is a good field because unlike other fields of law, it does not include moral values that much. For example, if you compare it with family law or inheritance law, engaging in comparative law studies gets more difficult because there are more factors in play. Whereas in contract law, the problems and the solutions you see are usually similar. And this is explained with the rule of thumb, presumptio similitudinis. This means, so if you are looking at a problem from a comparative perspective in contract law, it is expected that you would find similar solutions provided by different jurisdictions. If you do not find them, you should be careful. You should doubt your analysis and go back. And this is a rule of thumb usually adopted by comparative lawyers in contract law. So I will also give you a brief historical sketch of how contract law developed. Then I will go into the different legal traditions as well. He says, if you destroy the authority of contracts, the mutual intercourse of men is destroyed. So living in a society means that we have to be in contractual relationships with everyone, almost everyone around us. But this was not always the case. For example, if you look back in time, in prehistoric times or feudal times, you did not have that many contractual relationships. Why is that? Well, for example, in feudal times, the obligations of persons towards each other were not determined by contracts, but rather by status. For example, if you were a feudal lord, you were obliged to provide shelter and food for your subjects, whereas your subjects were obliged to work for you. But these obligations are derived from your status. When we come to the 18th and 19th centuries, we see a shift from status to contracts. After these dates, now the society moved away from agriculture and embraced industrial economy, and the importance of the division of labor was recognized. So following that, the idea of liberalism emerged, and based on all these developments, the importance of contract has increased. And these were the times when new codes were being drafted throughout Europe, especially in the civil law part of Europe. Here you see a list of important codes drafted in the 18th and 19th century, also reaching to the beginning of the 20th century. And when these were drafted, the prevalent idea, the philosophical prevalent idea, was liberalism. So freedom of contract was emphasized in most of these codes. For example, if you have a look at the Swiss Code of Obligations and the Turkish Code of Obligations, within the limits of the law, parties may freely determine the contents of the contract. So it was up to the parties how to regulate the relationship between them, and only in exceptional cases did the law impose some mandatory rules. These mandatory rules have in time increased. What happened? Well, as times progressed, pure liberalism was not that satisfactory, in the sense that there was a need for social justice. Because in legal relationships, in contractual relationships, you may have one party which is structurally weaker than the other one. And in that case, the legal order shall protect the weaker party. What are the examples of that? For example, in labor law relationships, well, the worker is in a precarious position, so the law shall protect the worker. Or coming to more recent trends, you have the consumer and the seller or the producer. In this relationship, the consumer is the structurally weaker one. So then you see later in the 20th century legislation emerging for consumer protection, etc. So let us now classify legal traditions. Well, there are many ways of classifying legal traditions, but the main distinction is usually made between common law and civil law. There are also countries which apply Islamic law, some partly, some fully. And especially before the fall of the Soviet republics, there was socialist law as well. Now, these days, the importance of socialist law is very limited. But now we also see that the post-Soviet countries have adapted new codes, new rules, which resemble civil law mostly. Some basic characteristics of civil law are as follows. You have usually systems built on codification. For example, we have the Turkish Civil Code, or the Swiss, you have the Swiss Civil Code, Code of Obligations. These systems are based on jus commune, therefore Roman law. As you know, Roman law was rediscovered in Europe after the 13th century, and it was applied as a secondary source where local rules were not sufficient to resolve certain disputes. what is another characteristic of civil law is it is the inclination to systemize and make abstractions. So when you look at civil law codes, you see there are very abstract rules. And when you are faced with practical problems, you have to put these practical problems under an abstract rule. This is how the law usually operates in civil law jurisdictions. This also has another result. The interpretation of those abstract rules is very important, and to that end, case law and doctrine is very significant, and we have seen an example of that in the first article of the Turkish Civil Code already. But when you look at common law, you see that, first to start with, common law is usually applied in England and its former colonies due to historical reasons. The unity of law is maintained by courts in common law, so not by codes, but courts. Case law is dominant. There is this which basically says that previous decisions by higher courts are binding in the later cases to be decided by the courts as well. And with that in mind, there is a distinction between ratio decidendi and obiter dicta. What this division means is you have what you call ratio decidendi is the actual rule of law that has helped the judge to solve the case at hand. So this part is binding, but what the judge had said in passing, obiter dicta, is not binding necessarily. It is an important authority, so you may rely on that in common law, but unlike ratio decidendi, it is not binding. Another thing you should know about common law is that the legislative sources, there are some, although case law is the most dominant source, there are some legislative sources, they prevail over non-legislative sources. So if the legislator has legislated, for example, this is the case with regard to Contracts Act of 1999, this prevails over former decisions. And another characteristic of common law is that unlike civil law, it adopts practical solutions instead of abstraction. So common lawyers do not try to create abstract concepts and work with them, but rather they look at the problem at hand and try to find a fair, equitable solution to it. We also find some mixed jurisdictions throughout the world, and these mixed jurisdictions are mixed in the sense they are a mixture of common law and civil law mostly. And as you will see, all of these have historical reasons. For example, if you look at Louisiana, you see that it used to be a French colony. Then Napoleon had to sell it to finance his war to the USA in 1803. And because of that, it still held on to its civil law tradition. So in Louisiana, you would still find a civil code, for example, but federal laws and the US Constitution are also applicable there. For example, the Uniform Commercial Code, which is an important instrument of contract law in the US, is also applicable in Louisiana. The second example is Quebec. Again, we see the influence of French law there. This territory was also lost to Britain by France, and they managed to preserve their legal system. French is still spoken there, and they still hold on to their civil law tradition. An interesting country is South Africa, where in the 17th century, Dutch colonists found a settlement and found a colony. And in that colony, they applied Dutch law. And what Dutch law was back then, mostly based on Roman law, Dutch Roman law, they had basically revised the Corpus Juris Civilis, and they applied it. So still in South Africa, you find some decisions citing Corpus Juris Civilis, which was drafted back in the old Roman times, in Istanbul, actually. But what happened later was that the British took over South Africa and they started to impose their own law as well. So at the end, it's become a mixture of common law and civil law. And lastly, you have Scotland. Scotland was a different kingdom from England in the past. And before the unification of the United Kingdom, they used to send their lawyers to be educated in France. That's why the French law had a lot of influence in Scotland. And this influence can still be felt there. They even have their own court system. They only share the Supreme Court in the UK. But Scotland is therefore seen as a mixed legal system. And lastly, a few words about Islamic law. As I told you, today there are countries that apply Sharia exclusively, and there are some countries who apply Islamic law only in certain parts, in certain fields of law, such as family law and inheritance law. But since we are talking about contract law, I should tell you that some rules that you find in the Quran are not that different from the Western rules of contract law. For example, you have this passage where it says, "O you who believe, fulfill contracts." That's what we would call the binding effect of contract on the parties. There are some other rules which are comparable to the civil law countries or common law countries even, but perhaps a relevant prohibition with regard to practice concerning contract law is the ban of loan interests in loans. So you may have heard of Islamic banking, for example. This is created to allow customers of banks to take loans or give loans in a Sharia compliant manner. So you see the effect of Islamic law on contract law in that area often. And the last part of my presentation concerns harmonization of contract law in the EU and in the international context. So we have to start with the EU when we talk about harmonization, because as you know, EU aims to develop a single European market where free movement of goods, services, capitals, and persons is established. And to allow that, the differences of legal rules should be eliminated to a certain extent. And contract law is a field of law where such need becomes evident. Why does the EU try to harmonize certain rules on contract law? Because they want to facilitate cross-border trade. Different rules make that more difficult. They want to create a framework for EU law governing contracts. And they wanted to provide a guideline for legislators, for example, in the post-Soviet countries, where there was an imminent need for new rules after the fall of the USSR. And lastly, forming a dialogue between civil law and common law. This part was especially important because of the UK, because as you know, they were part of the EU until recently, and establishing a dialogue and finding common ground between common law and civil law back then was very important. So when we look at the current EU legislation on contract law, we observe that mostly directives ensuring minimum harmonization for consumer protection constitute the core of such legislation. And lastly, I should note that EU was instrumental for fostering comparative academic research in contract law because they have given funding for that, as we will see. There is a very brief overview of the development of EU contract law. First, we start with 1989, where the European Parliament, in a resolution, stated that there needs to be a start made on the necessary preparatory work for the drawing up of a common European code of private law. So this was very ambitious and did not happen at the end. But they also said aid should be given to centers for comparative legal studies in the community and to endeavors at codification in general. So what the EU did, they reserved some funding for comparative law, and which has given some results, some important instruments, such as the Principles of European Contract Law, the PECL, the so-called PECL, and the Gandolfi Code, which we also use in our lectures on contract law. And then in 2001, we see a communication from the European Commission. There few options were outlined as the way forward. One solution was, well, let's leave it to the market and do nothing else. A second option was, let's adopt common but non-binding rules on contract law, and this can be used as drafts for legislators, etc. A third option was, well, let's focus on what we have been doing so far, improve the directives. And fourth, and the most ambitious option, was to adopt a European contract code, but that was on the agenda in 2001, but these days we see that this is not possible. Another communication came in 2003, where it was decided that the EU should prepare a common frame for reference. So when I was talking about the 4 options before, the second option was adopted. They wanted to create some rules as a toolbox where appropriate when presenting proposal to improve legislation, the quality and coherence of the existence acquis communautaire, and future legal instruments of in the area of contract law. So we have seen that the EU has given up on a common European contract code, but rather started to draft some non-binding soft law instruments. In 2008 and 9, finally, there was a draft of this common frame of reference, and it's published in 2009. We also use that in our courses to have a look at how legal scholars have found some common ground with respect to legal problems concerning contract law. And then we have lastly an important failed project, which was a proposal for regulation on a common European sales of law. This was a very hot topic back in the day, but in 2014 it was withdrawn. It was a failed project. It turned into a directive, simple directive on the digital content. And it's in force since 2019. I would like to lastly talk about two more international instruments which are important in contract law. The first one is the Unidora Principles. This is a soft law instrument, so it's not binding. It is not a European instrument, it's an international instrument. And what the Governing Council of Unidora says about the objective of these rules is that the objective of the Unidora Principles is to establish a balanced set of rules designed for use throughout the world, irrespective of the legal traditions and the economic and political conditions of the countries in which they are to be applied. So again, these rules are drafted with the aim of finding common ground, especially between civil law and common law. They are good rules for international commercial contracts. That means they assume that the parties to this contract are not in an asymmetry with regard to their bargaining power, for example. So consumer contracts are not eligible or a good fit for Unidora rules. But we have said that these are soft law. So when and how can these be applied? So the first option could be parties themselves can agree that this will be applicable law for their contract. That is one option. This usually sometimes happens with regard to disputes solved through arbitration. Secondly, it may apply as lex mercatoria or may be useful in interpreting and supplementing other legal instruments. For example, Unidora rules are sometimes used to interpret and supplement the CISG, which I will talk about just in a minute. And lastly, there are 4 versions of this Unidora rules. The latest one is from 2016. So these rules are being updated throughout the years. Lastly, the UN Convention on International Sale of Goods, the CISG. This is perhaps the most important and the most successful international instrument with regard to contract law. The first reason is it's not soft law. So this is an international convention, and parties to this convention, once they ratify the convention, the rules of the CISG become part of national law. What does it regulate and what does it govern? It governs international sales, and the objective was to eliminate obstacles to international trade, and it succeeded because it is a very simple text when compared to national codes. It's even someone who is not a lawyer could get the idea by reading the provisions. It creates a good balance between the buyer and the seller. It entered into force in 1988, but countries have been becoming party to it throughout the years. And it has 4 parts regulating sales contracts in general. The contracting states are mostly the whole world. I mean, not the whole world. Let me show you a map where you can see the coverage of the CISG. This is not very up to date. For example, Portugal has adopted CISG as well, so this should be gray as well. The gray areas are countries where the CISG has been adopted. You will perhaps notice that 2 countries which are important actors in international trade are missing from the gray areas. One is the UK, and the second one is India. This is an incomplete incomplete list of flags. I had done that a few years back. Since then, new countries should be added here, but just to give you an idea. So with that, I conclude my presentation, and thank you all for listening. Before I finish, I would like to give you an information about the course itself as well. Well, I have told you already what I will do in the course, but you should also know what you are expected to do in the course. During the course, you have to take exams. You have to make a presentation, and you have to write a seminar paper at the end of the term. Actually, we also have a guest lecturer in this course, Professor de Elizalde, who comes from Spain, and he also teaches about the European contract law, mostly matters of European contract law, in 2 weeks. So having said that, I conclude my presentation and leave the floor to Melissa, who is still muted.
Sorry about that. Thank you. So yes, thank you so much for the sample lecture. I'm not a lawyer, but I did learn a few things, and also surprising things about how the history of this field has evolved over time. So thank you. I think most of our participants today are lawyers, so they will have different questions for you, I'm sure. So with that, I will share my screen again. If you just bear with me for a couple of seconds, so that I can now invite Professor Aisha Gulbura to give us a brief overview of the LLM programs at Koç University. And I will kindly ask her to unmute herself, and then you can introduce yourself, and then we can start.
Thank you very much, Melissa. Well, my name is Aisha Gulbura, and I'm currently acting as Associate Dean of Koç University Law School, and at the same time, I am directing the Dr. Nusret and Samat Arsel International Business Law Research Center. I will try to keep this brief in order to be able to leave a bit of room to Ms. Özcan for the admission part of this presentation. I will try to begin by giving an overview as to why choosing to do an LLM at Koç University would greatly contribute to your career. Well, the first reason is that you will be taught by faculty members who are internationally renowned and who are dedicated to train a new generation of lawyers. If you haven't done that, I strongly recommend you to go on our law school's website to see our faculty members and their backgrounds, and you will immediately see that they graduated from reputable universities, reputable institutions in the world, and that they are dedicated legal scholars. We also have, as Işık Hoca mentioned a few minutes ago, we have both full-time and part-time faculty members who are teaching on our LLM program. And you will notice when you go on our law school's website that some of the part-time lecturers come to Turkey from a variety of countries to teach. And some of those countries are, for instance, and include the United Kingdom, Spain, and Mexico. Another reason perhaps to mention as to why doing an LLM at Koç University is something that you should definitely consider is that we offer an international environment to a qualified group of graduate students, and they are provided numerous opportunities throughout their studies to improve their academic skills as well as their awareness regarding the contemporary comparative and international topics of different legal disciplines. The courses are modular and last usually from 6 to 8 weeks. Our lectures are scheduled on Fridays and Saturdays, which in a way permit our students who work at the same time to pursue an LLM and to be able to attend the lectures. As a last point, perhaps, I should also mention that we believe that the tuition fee of the program is fairly affordable, and we also offer some financial opportunities to some students. in the form of fee waiver, which will be touched upon later by Ms. Özcan. And I have just realized that there is actually a question in this regard in the chat box, which I believe will be answered a bit later. So please do bear with us. Next slide, please. Yes, thank you, Melissa. So in total, we offer 2 tracks, namely LLM in private law and LLM in public law, as you can see on this slide. If you prefer doing an LLM with thesis, you will be required to take 7 courses, following which you will have to write a thesis. In this case, the program will have to be completed in 2 years. If you choose to pursue a non-thesis LLM program, then the number of courses that you will have to take will be 10, and you will be required not to write a thesis, but to write a final paper, which requires less effort compared to writing a thesis. And in this case, the program will have to be completed in 1 year only. Because the main difference between these 2 programs lies in the writing of the thesis, because they're both taught programs, and I believe the thesis part is really the differentiating element in between those 2 programs, I would like to say a few words about the thesis and the final paper. The topic of either the thesis or the final paper is chosen by the students themselves. And this is done via a consultation of the students' supervisors. So the students are free to choose their supervisors, and they're free to choose the topic of either the final paper or of the thesis. So if the students are rather interested in contract law, or let's say in maritime law, they would need to approach the professors teaching in these areas to basically write their works under the supervision of these professors. So that in a way gives students to focus in a field of law of their interest. Next slide, please, Melissa. Yes, thank you. So you see the courses that are offered in the LLM in public law, LLM in private law, and you see some common elective courses. The ones that you see in the middle are the compulsory courses that you will need to take if you are enrolled in an LLM in a private law program. And the students may obviously elect some of the common elective courses that you see on the right-hand side in order to complete the taught part of the program. Just to give you an idea about one of the courses that is mentioned in the middle column, World Trade Organization Law, this is actually a course delivered in English and in most of the circumstances in the fall semester by one of our visiting professor, Dr. Amrita Bahri. And because WTO law regulates trade relations and dispute settlements between states, the course has actually both a public and a private law angle. So even if you are interested in rather public law courses, you may very well choose to enroll in this course as well. And because contract law has been touched upon to a great extent by Dr. Önay, I will not elaborate on that any further, but I will be happy to elaborate on the courses that we offer should there be any questions in the Q&A session. I think that's it from my side, and I will be happy to receive questions if there are any in the Q&A session. Thank you.
Thank you, Professor Bura, and thank you, Professor Önay. Now I'm going to talk briefly about how you apply to the LLM programs and what are deadlines and some criteria that we are looking for when we evaluate the candidates. So this year we have one intake where we apply, the applications are for 2021 and 2022 academic year, and the semester starts late September. So the applications due on 21st of June. So you have plenty of time to apply on our online application form, which is apply.ku.edu.tr. You can reach that site from all our web pages, both from international admissions website and from the law school website. So the applications are just to, what we will talk about basically about the criteria. but the applications are evaluated on the candidates with the committee members. And then can we skip to the next slide first so we can talk about the criteria first? Yeah. So we first look at these applications and the documents that they submit on our website, on our application form. The criteria to apply for an LLM, the most important criteria is that you need to be a graduate of an LLB program. So if you studied a different bachelor degree, you cannot apply for LLM programs, unfortunately. So if you should be a graduate of a bachelor degree in law. And the minimum criteria from the graduate grade point average is 2.75 for the thesis programs and 2.50 out of 4 grade for non-thesis programs. And the language required is really important because the program is held in English. So we need TOEFL degree, YDS, are language exams based in Turkey. So if you're an international student, you need to have a TOEFL degree. And we also, there's an also international exam, IELTS. You can apply for it if you have an IELTS degree, but then the IELTS is not accepted in Turkish institutions, therefore you can apply. But if you pass the evaluation status, then you will also provide a TOEFL exam score. These are, of course, for non-native English speakers. If you are a native English speaker, then of course, you're not required to submit a language score. And there's also an LS requirement for Turkish students. This is an academic graduate education for non-thesis programs. There is no ALES requirements. And also from international students, of course, we do not ask for ALES program score. The tuitions for both programs, both for with thesis and non-thesis programs, the tuition fee for the whole program, not for 1 year, is 76,500 Turkish lira, which is 11,000 US dollars. You can pay it in 2 quotas for both programs. And if you follow non-thesis, it's again the same price, but then of course, you will have this 2 years education period, and if you follow non-thesis, the tuition will be the same. Next slide, please. And the most asked questions that we get, of course, the tuition and also the scholarships opportunities. We do provide tuition fee waiver, as Professor Bura mentioned, but it is on academic success. It's an academic merit base. So when you apply and if you are shortlisted, the committee will invite you to an interview and an academic exam. So based on your performance in written exam and interview, the committee might give you scholarships, which is a tuition fee waiver on some amounts, which can be 25%, 50%, or 100% if you're really successful. For non-thesis, of course, we sometimes provide scholarships like tuition waivers up to 25%. If you're really successful, if you perform very well in written exam and interview, and if you wish to follow non-thesis programs, yes, you can receive up to 25% tuition waiver. Next, if you have, yeah. And finally, we also had a question about this, and Melissa, thank you, you answered that. We also have an extra session for public law program on Thursday, 28th of January, with Professor Işıl Aral. She's going to talk about theorizing public international law. And after her lecture, we're going to follow the same structure with Professor Bura, and then me, I will answer admission questions. If you're interested in public law, or if you haven't decided yet, you can join both sessions and learn more about our programs. Thank you very much.
Okay, thank you very much, Esra and Professor Aisha, for the overview of the programs. Now we have arrived at the question and answer part of today's webinar. So we are going to start checking questions that you may write on the Q&A part. So we know it's a lot to take in. You might still be thinking about some of the, concepts and authors and, examples shown in the sample lecture. So please feel free to start typing your questions. We have one question here regarding scholarships. So I think that has already been answered by Ms. Esra, that we do have available scholarships for the Thesis, LLM with Thesis program, and they're based on academic merit. So it's just to reiterate. So I'm going to mark that as answered. So if I think we have about, yes, like 5 minutes for questions. If you're thinking of other questions that you want to ask, whilst we do that, I'm just going to show you here some of our contact details so you can keep in touch with us if you consider preparing an application for admission for this fall semester. Of course, our guidance is always to first check the law school website and the Graduate School of Sciences and Humanities website, because you can find, as previously mentioned, you can find the faculty members, the course structure. You can also see some of our current students, not only in the LLM program, but also in the PhD in law program. And if you're interested in specific guidance and as an international applicant, you can also check our international admissions website. Of course, everyone is on social media as you are, so you can also follow events that we will be organizing. We mentioned one, which is public law, or LLM in public law sample lecture later this week. And later in the year, before the application deadline, we will probably have another couple of sessions just more focused on the admissions process, in case you have missed this one. So with that, let's wait for questions. And if there are no questions, I guess it means that we did a very good job. I hope that everything was very clear. Or if you're shy and you don't want to ask questions, please know that you can ask questions anonymously as well. Okay. So we will wait a bit. Okay. So there is a question here. Since the LLM program in Koç University is very competitive, to what extent is ALES points important? Is ALES considered only an admission requirement? So I guess, that's applicable for Turkish applicants. So
yes, it is only for Turkish applicants, but it is only to apply for the program. So the real thing to admit as students is your academic success during the interview and written exam. So if you have an ALES score 100, and if you perform really low during the interview and written exam, unfortunately, it will be a no to your admission. So it is not only ALES, it's mostly the academic success during the application period. If Professor and I, would you like to say a few words? You are in the committee. Yeah. Yes, Melissa, you were saying something.
Maybe we can mention about this year's specific circumstances because of COVID, that, the ALES exam has been also postponed, or, the date has not been.
Yes, we forgot to mention that most of the exams are delayed due to the pandemic. So if you don't have ALES score, if you cannot join this exams for language proficiency exams or ALES, you can still apply by the deadline. So we still evaluate those candidates to see their academic performance for interviews and written exam. And if they're successful, we can give them conditional offers. And you can still apply if you cannot have the ALES score or language proficiency scores.
Okay. So we will mark this as answered. Are there any other questions? We see there's a lot of Turkish participants in today's webinar. So if you have any questions, if you wish, you can also type your questions in Turkish and we can answer them in Turkish and then give a brief summary of the question in English. Okay. I guess not. I guess we have answered pretty much everything today. So in the spirit of keeping up with the scheduled time of the webinar, if we don't have any more questions, then with that, I would like to ask our panelists today to open their microphones and if they want their cameras to say goodbye. And with that, we will close today's webinar.
Goodbye.
Thank you very much for joining us.
Thanks for attending, and bye-bye.
Thank you very much and see you soon. Thank you.